Welcome, everyone. It is very exciting to see the numbers of attendees just climb as we kick off this virtual panel discussion. Thank you for joining Seyfarth Shaw and our other panelists here today as we talk about employee political speech at work and on social media, the legal and practical considerations. All participants are in listen-only mode. If you have any questions throughout the program, please use the Q&A section located on the right side of your WebEx window. We'll do our best to get to everyone's questions, try and fit them in where applicable, but definitely get to at least some of them at the end of the discussion. We are also going to have interactive polling during the presentation for all of those who are able to join the webinar. We ask that you participate through voting if you're not just dialed in through your phone. The polling questions will appear on the right side of your WebEx window. For those interested in CLE credit, an attendance verification code will be read about halfway through the presentation. Be sure to write the code down. It will not be repeated and is required for CLE credit. CLE credit submission instructions, the presentation recording, and this slide deck will be distributed to the attendees in the days following the presentation. So we do, next slide, we do need to just, as every presentation has its legal disclaimer, as we're discussing this topic. And to introduce the panelists of today's discussion, Dr. Murray is the special assistant to the president and a tenured associate professor of corporate communications at the University of Houston downtown. She received her bachelor's, her master's, and her doctorate from the University of Alabama, with her degrees being in political science, social work, communication studies, organizational communication, and management. She participates in a leadership role focusing on the initiatives of the president. She also teaches courses in leadership, organizational training and development, and a course I would want to take called Destructive Organizational Communications. She also conducts communications research when she is not otherwise occupied with teaching, facilitating the goals of the university, and researching. She's also a marathon runner and a bibliophile. Our second panelist, Victor Wright, is the Director of Global Labor and Employment Law at KBR. He is on the board of the Association of Corporate Counsel and has chaired and co-chaired the Labor and Employment section for that group for many, many years. He has practiced, and he's been in private practice, he's practiced in-house, he's practiced with JAG while he was in the Air Force. So he has a wealth of experience to draw upon during today's panel discussion. He's a trusted advisor and has a great sense of humor. Vanessa Rogers, who is helping lead this presentation, is an associate at Seyfarth Shaw. Her practice focuses on all things employment. She regularly defends employers in litigation and administrative matters and provides proactive counsel to organizations, including drafting and updating employee handbooks and policies, providing training to our clients, and conducting workplace investigations. My name is Danny Sanchez. I joined Seyfarth Shaw as counsel about a year ago. I've been practicing labor and employment for 15 years, with 10 of those years being in-house. Similar to Dr. Murray, I am a runner and a bibliophile. Similar to Victor, I like to think I have a good sense of humor, and similar to Vanessa, love to do all things employment. And so with that, we'll go ahead and look at what we hope to accomplish, our objectives for today's panel discussion. Sort of 6 topics that all blend together when we're looking at political speech in the workplace. The First Amendment comes into play, obviously wanting to provide some practical tips, looking at the NLRA, which isn't always your first thought when you think about political speech, talking about some policies and internal protocols, how anti-discrimination laws have a very close nexus to this topic, and perhaps from that very practical standpoint, how do we handle these issues and help diffuse these issues beyond just the legal context that we're talking about them here today. So with that, our first topic around free speech, First Amendment. And so many times we hear, you know, don't I have a First Amendment right to freedom of speech? And you hear that from employees so often. Vanessa, can you talk to us about, is that right? Talk to us about that First Amendment right to free speech.
Certainly. So it's not quite right. I think that a lot of employees would like for it to be the case that they have First Amendment right to say whatever they want to at work. But in reality, the First Amendment really only applies to and limits the government's restrictions on speech. And so there's no essential right to free speech in the private sector, but there are some rights in the government. However, the Fifth Circuit has recently ruled that a Texas district attorney didn't violate the First Amendment by firing the coordinator of his crime victims unit for having differing political beliefs. And that's because the court looked at what it considered political loyalty. It said that some roles, in fact, require loyalty, and therefore employers, even in the public sector, don't run afoul for terminating or disciplining employees who have differing political views. Like I mentioned before, as it relates to the private sector, though, employees don't have a general right to First Amendment free speech. That means that private employers, they can generally control the speech and expressions at work. That includes dress codes, things like face masks, T-shirts, hats. They can also control what's posted on company bulletin boards. Probably the one that we most commonly think of is the verbal communications that employees have with each other. We'll jump into our first poll question for today. And the poll question essentially is, does your company have a political speech policy? So if you look on the right, you should answer yes or no to whether your company has a political speech policy. And if you don't mind to just take a few seconds to complete that so that we can have more of a discussion about it. In the meantime, though, I'd like to ask Victor, since he has lots of experience in different roles at different companies, what he's seen in terms of political speech and policies that companies have implemented.
Sure. So thanks, Vanessa, for the question. And first, also thanks, Danny, for the warm introduction. It's a pleasure to be here this afternoon. So answering that question, KBR, where I currently work, so Kellogg Brown and Root, does not actually have a standalone political speech policy or political expression policy. What we do is we rely upon our Code of Business Conduct, which is loosely grounded and fundamentally grounded in having mutual respect and dignity in the workplace, ensuring that for our employees. In preparing for this, I actually did some research, and I'll be interested to see how the poll turns out. About 79% of companies actually don't have a specific standalone political expression policy or speech, but more and more companies, I think, are thinking about that in this day and age of this politically charged environment. As I mentioned, that was mentioned during my introduction, I formerly served as a judge advocate in the United States Air Force. And when I served in that capacity and practiced labor and employment law, we actually did have a political expression policy for military members and for federal civil servants. That was grounded on a 1939 federal law called the Hatch Act. And so we provided a lot of do's and don'ts about what civil servants and military members, who I would say actually have the ultimate loyalty to the country because they serve, they serve the country regardless of political party who's in the office. But if you're thinking about venturing into the area of developing a political speech policy, I would just give you 4 best practices. And one would be to set limits for appropriate expression in the workplace, such as when and where it can take place, whether that takes place in the break room or outside during breaks at lunch hours or things like that. Also, to make sure that you encourage dialogue and respectful discourse in the workplace. I know sometimes that can be challenging to do in these particularly divisive times, but it is something that you want to make sure that the discourse remains always at a respectable level. Number 3, focus on positives and not negatives in your policy. Don't just have a list of things that you are going to get in trouble for particularly, but also have things that are positive of why it's good to engage in exercising your right to vote, doing voter registration drives and that sort of thing, and why it's important for even private practice and private sector employees to participate in the political process. And then finally, you want to avoid having a policy that's overarching, broad, and vague. You want to get specific, and you don't want to have a lot of margin for error for people to interpret it because, as we know, things can be, and we'll see in this presentation, even words can be interpreted by folks in different ways. So that would be my best practice advice if you're elect to venture into the world of developing a political speech policy.
Thanks for that, Victor. And I think that you hit the nail on the head in terms of the results that we're seeing now in terms of companies who actually have a political speech policy. You know, you said your research was about 79% didn't have it, and we've got the majority, a large majority, I should say, of the folks here today who also don't have a political speech policy. So I'd like to pose a question to Dr. Murray. So for those companies who are hesitant to allow free speech, or I should say unlimited, unrestricted free speech at work, are there different outlets that you would recommend for employers to maybe implement to allow their employees to have an outlet for free speech?
Okay, thank you for that question, Vanessa, and good afternoon. So just quickly, I'm a storyteller by trade. My background is in higher education and the nonprofit sector. And so when I think of workplace organizations, I like to think of my organization as a utopian place that I would call Wakanda. We're all familiar with the comic book series turned blockbuster hit Wakanda, correct? And we know that Wakanda was this country that was made up of these 6 Wakandan tribes. And so we can look at our organization is the country of Wakanda, and the various departments we will equate to the various tribes of Wakanda. And within all of those various tribes, there were different values, there were different cultural signifiers, but they all made up the great nation of Wakanda. And we can think about our employees as members of these tribes. We think about they need outlets so that every employee, every department has a different need to be successful in the organization. And we can think that these tribes or these employee workplace resource groups, these affinity groups, designated programs that organizations have are places where employees can describe when they're feeling discomfort in the workplace or particular angry about an issue. And they're also places when we think about these Wakandan tribes where you can share a commonality, and it's a safe space to come to look at and discuss with other employees about issues that you are experiencing in the workplace. And so I do think that as we look at overall organizations and our cultures and our values, that it is important for companies to have places where their employees can go, talk, relate, vent about what is unique about their particular Wakandan tribe.
Thanks for that, Dr. Murray. I think that's very helpful. And I love the reference to Wakanda. So with that, we've spent some time talking about, speech at work. So I'd like to ask Danny, once an employee leaves work for the day, does that mean that they're free to express their political views from then on?
From a very practical perspective, right, they walk out of the organization's doors and they have a right to free speech. But as with everything, it definitely can impact their employment in the way that they choose to exercise it. So an individual who works for a company, leaves for the day, and uses their free speech to express views that are contrary to the business and can hurt the business's clientele, can hurt the profitability of the business by creating public relations scandals, the employer is going to be able to take a stance and take an adverse action or be able to impact their employment based on that free speech that they otherwise were able to exercise. That's sort of one example of how, even though you may have free speech, the workplace, your employer can still, as employers, we can still exercise some control over who it is that's representing us as our employees. And then the other side of that is whenever that free speech goes too far, and that is it's offensive, it's harassing, it's threatening, and it bleeds back into the workplace. So something that somebody says to someone outside of work makes the person feel uncomfortable inside of work, whether it's because it's a racial epithet or it's a threatening or harassing speech to that person, it can bleed back into the workplace. So employers have to be responsible for managing that type of conduct as well, even though it happens outside of the workplace. And we have another poll question.
We do. So the next question that I would like for the group to answer so that we can discuss more of is, does your company have a social media policy? So a lot of times we are seeing that the employers may try to control outside conduct, like Danny was mentioned, through social media policies. So if you don't mind to take a few seconds there to fill out that poll question, and as the results come in, Victor and I will have a discussion sort of about what he's been seeing based on his experience. You know, tell us, Victor, if you don't mind, what kind of social media policies have you worked with in-house, or those that some of your colleagues may be implementing at other companies?
Sure. So thanks, Vanessa, for the question. Yeah, so with this one, we do actually have a social media policy, and we've had one for some time at KBR. And within the company, it's actually owned by the legal department, who's the content owner and the process owner as well. And so in implementing that policy, we work very closely with the legal department with our HR department as well. And fundamentally, that policy is grounded, once again, on our Code of Business Conduct, which requires mutual respect and dignity. So we have a basically admonition to employees to be respectful in their comments that they post. As Danny mentioned, what people put on social media can come back to hurt the organization and expose the organization to harassment claims if the comments that people post go too far. What's interesting, what I'm seeing in this remote work environment that we're in, is that people are spending more and more time on social media, whether that's Twitter or LinkedIn, Instagram. We have internally now, because we're remote, we have an internal Yammer where individuals can go internally and post things, almost just kind of like texting each other or different things like that. So it is important to have a social media policy that regulates those comments that are put on there. And also what I'm seeing from other companies is that they're revisiting their social media policy because of the times that we're in. And some of the most effective social media policies are ones that actually provide examples of what goes too far, some do's and don'ts, that set clear guidelines. Because as we'll talk about later in the presentation, and as we also have in our social media policy, it is best practice to have a policy that does mention the National Labor Relations Act, and that does not prohibit employees from engaging in protected concerted activity. So you want to have a social media policy that, again, that provides examples, that's specific on do's and don'ts, that protects your proprietary information, that can hurt company confidential information if it's disclosed through social media. And you also want to have one that complies with state and federal law.
Thanks for that, Victor. Very helpful points on the social media front. The poll results are in, and I can't say I'm surprised that most companies do, in fact, have a social media policy. Looks like 173 of participants polled yes, they do have a social media policy, while only 24 said that they do not. So right in line sort of with what we were expecting. And for those who do, please take Victor's suggestions on how to sort of craft that social media policy. Danny is going to discuss a hypothetical with us as it directly relates to social media.
Victor mentioned, with so many people spending more time online, these situations are coming up more and more. On Facebook, in this hypothetical, employee A makes a scathing rebuke of the SCOTUS decision protecting LGBT employees and applicants from employment discrimination. In doing so, employee A uses offensive epithets about LGBT individuals. Employee B, who they're friends on Facebook, sees the post and complains that it is offensive. This hits your desk on a Monday morning, Victor. What do you do with it?
Wow, yeah, it does hit my desk. And in working with HR, these issues come up because HR is the front line of defense in terms of problem solving, and often rely upon the legal department to provide support. So with this one, even before I get into the specifics, I think I like to take an approach where I analyze the situation. We take a deep breath, because these are emotionally charged times. And I think you need to make decisions on, if you're taking disciplinary action, you need to do it with a cool head and stay calm under pressure. And so by that I mean, you have to look at the facts and investigate before, and get all the facts and the details out there. Such things as whether or not this conduct occurred off duty or on duty could be relevant. Whether this is a manager or a non-supervisor. Also look at the substance of the posting and the location where it took place. So, and I would give advice to provide a question framework, in addressing this. Does the conduct violate a company policy or workplace rule? Number one. Is the conduct consistent with reasonable and legitimate expectations for the workplace? And then finally, does the conduct implicate protected activity? So using that framework and turning it to this particular question here, this hypothetical, I would actually kind of break this hypothetical up into two pieces. When the individual employee A is talking about the scathing rebuke of the Supreme Court decision, looking at that standing alone, that may not be, prohibited in, analysis or posting. I mean, for example, is the person commenting upon, the justice's legal reasoning when they reach that decision? Or are they, going into an area that maybe express their conservative views or political views there, but it's not, they have a right to do that if it's occurring, off duty. If it's during the workplace and these postings are taking place, our social media policy does find impermissible excessive use of social media, so we might look at that. But we would take all these factors into account. Now, the second part of the hypothetical, when it talks about in doing so, employee A starts using offensive epithets about LGBTQ individuals, that's where we're now crossing the line, because now the individual is now, taking demeaning and disparaging remarks toward a protected class, which that decision actually now brought LGBTQ employees into that protected class. So that would be something that we look at as possibly subject to disciplinary action. And in our particular policy that we have, our social media policy, social media postings can result in immediate termination without going through a progressive discipline and giving folks a couple of bites at the apple before they're let go out of the organization. So that's how I would approach this. Again, the bottom line, though, is you want to apply your policy objectively and consistently, and be sure that your decision takes into account all of business-related reasons and make sure it doesn't cause an adverse impact on employees. That's how I would approach this hypothetical, Danny.
One of our participants asked what I think is a good question that a lot of people may be thinking. Do employers have a responsibility to respond to the complaint to them only, or is there any responsibility to actively monitor social platforms of their employees?
Yeah, that's an excellent question. I think employers have a duty to monitor what's going on in social media, and should, because it's an extension of the workplace, essentially. And so I think there's a duty to monitor, and I think there's a duty to take action if the conduct is discriminatory, found to be discriminatory toward a protected category of individuals. So yes, I do, and our actually policy does allow us to monitor, and before individuals go into social media, they have to click on the acknowledgement that they consent to the employer or the company monitoring their social media activity, if they're using our computer system while doing so.
I think that those last 2 points are really great and really crucial about using your systems. They've done something to actively consent, and it's happening in the workplace. This social media component makes things so much more complicated in the world of communications. Dr. Murray, can you talk to us about how that communication is different when we take the same things you and I are saying and, now stick them in a little text box?
Yes. When I think about everything that Victor just shared, he hit the nail on the head. When it comes to our social media, our personal expressions are reflected through our social media. We have to realize that our various social media accounts are extensions of who we are. And if I can refer back to my Wakanda example, we're all different, and it's safe to embrace the difference. We have to think that most of us spend our lives ingrained in our company culture, and so we select, we stay, we thrive at an organization based on the culture created by that particular organization. And so it's the job of our organization, thinking about the question that was asked in the chat box, to create a fair and equitable and tolerant workspace. Everyone has a different lived experience. Everyone has a different social position. And as an organization, as leaders in organizations, we must remind employees of the social media policy and look at more closely, how are we as leaders, how are HR managers engaged in training our employees as it regards to difference in the workplace, in diversity and thought, diversity in speech.
Thank you, Dr. Murray. One of the other, another participant asked a question about states with laws prohibiting discrimination based on lawful activities outside of work. So Vanessa, will you go ahead and address that with this slide as well?
Yes, that's right on point, and where we were going with the presentation. So as Danny had mentioned earlier, in most states, employers can prohibit certain political speech and expression during non-work hours for those reasons that she stated before. But there are some states out there that have passed laws to protect employees as it relates to their off-duty conduct. States like New York, California, Colorado, North Dakota, they've made it unlawful to prohibit an employee from engaging in lawful conduct. And that lawful conduct could be things such as attending protests or rallies, or any other politically charged events. So when companies are thinking about prohibiting off-duty conduct, also be mindful of the states in which you have operations, the states in which you have employees, because different states have passed laws that make it unlawful for an employer to prohibit these types of off-duty conduct. There are also states out there that prohibit discrimination based on political beliefs. voting patterns, political affiliation, those sorts of things. And additionally, there are states that prohibit threats or promises that are directed at political activity itself. So one of the states, which I'm sure nobody is surprised about, but California does have additional protections that it provides to employees as it relates to politics. And this slide here is more of a reference slide for those employers who have employees in California or operations in California. But essentially, California law prohibits employers from having a rule or a policy that prevents employees from engaging in political activities, or for employers, prohibits employers from trying to control or direct an employee's political activities. And I should say here that political activities isn't just voting. It isn't just partisan activity. It can also mean supporting social movements like LGBTQ movements, like Black Lives Matter movements. So employers who are affected by this California law should be mindful of these additional protections that the state has passed as it relates to politics.
Connecticut is another one of those states that extends additional protections to some of their employees. They extend that First Amendment free speech protection, not just for public employers, but also for the private sector as well. So it's important that if you have issues that come up in states, whether it's California, Connecticut, Vanessa mentioned several other states that have off-duty protections, to look quickly to see if that state has some additional protection. And Texas, that's where the four of us are all located, has certain protections for its employees specifically related to voting, such that it's a felony if you try and retaliate, discriminate in any way based on their voting, on refusal to share how they voted, things of that nature. So Texas has, and most states have some protection related specifically to being able to go and vote. The CLE code, for everyone who's listening, this is about halfway through our slides. So the CLE code for everyone is SS4541. Again, that CLE code is SS4541. And Victor, now that everyone's listening because they wanted the CLE code, can you share with us how do you, in your role with KBR being so geographically dispersed, how do you manage the multiple states and the variety and what the laws may be in all the different localities?
Yes, thanks, Danny. So in short, it's challenging, right? So being a multi-state employer, you have to consider the state law implications, and that's why I think HR and legal in particular have to work so closely together, because it's an issue of being able to spot the location where the behavior or the activity is taking place. And so what I've seen in my experience, because KBR isn't the first in-house job I've had, I've actually worked at another company before coming to KBR in an in-house role, is that most multi-state employers will look either to do one or two things. One, develop a policy that looks at the state where they operate that's the most restrictive or most liberal, depending on the type of policy. So say, for example, California, and draft their policy to apply across all of their operations using that as the standard, because that's, if they're compliant in California, then they're going to be compliant in Massachusetts or Florida or something. For us, we actually don't do it that way at KBR. What we'll do is provide qualifying language in our policies that we will set a standard that's consistent with our corporate values, and we'll put in qualifying language to say something, for example, may be prohibited unless as may be otherwise required by applicable state law. So if we provide that carve out in our policy such that we can then look to California or Connecticut or Texas or South Carolina or some of these other states to figure out whether or not there is a state law that provides protections to employees for engaging in political expression. Just one quick example, we just recently had one in the state of South Carolina, where we have operations there, and South Carolina allows employees to engage in political activities outside the workplace. And even with respect to the Confederate flag and whether or not someone could have the Confederate flag as a bumper sticker on their car, and whether or not that was protected activity. And in the state of South Carolina, it is. It can be, depending on the facts and circumstances. But we had to assess South Carolina law in that situation with respect to the Confederate flag, instead of just taking a strict, prohibition against someone being able to display that.
Thanks for that. I just want to make one clarification. That was on the CLE code. It was SS, like Seyfarth Shaw, SS before the numbers. Sorry, go ahead, Vanessa.
Thanks for your notes or your comments there, Victor, especially as it relates to the Confederate flag. That sort of plays in nicely into one of the things that I wanted to discuss, which is the intersection between employee political discussion and symbols in Title VII, right? So employers cannot allow free speech and expression that creates a hostile work environment. Oftentimes when we're thinking about hostile environments, we're thinking of words, conversations, things that people are saying to each other. But we also have to remember, like Victor was saying, that symbols can play a role too, right? So the Confederate flag has come up often, as it relates to whether or not that symbol itself creates a hostile work environment. The EEOC and some courts have found that the symbol does contribute to creating a hostile work environment, and it's meant to demean, intimidate, or harass people on the basis of their race. So it's important to know what law is applicable to you as it relates to the Confederate flag. Be mindful that we're talking about not just words and actions of employees, but also symbols that can create a space that creates a hostile environment for others as well. Another thing for employers and companies to keep in mind is that these policies that you establish as it relates to political speech and expression need to be viewpoint neutral policies, right? So, for example, an employer could possibly face a lawsuit if it disciplines an employee for displaying the Quran at work, but allows another employee to display the Bible, right? So we have to take an approach that is neutral on the policies, and then we also have to take an approach that where the enforcement is the same. It's even-handed enforcement. So Danny's going to discuss another hypothetical here as it relates to political speech and expression.
This one, is very easy to see both conceptually and it happening. An employee in a cubicle has a photo on her desk of a boy holding a sign, the sign reading, "Stop White Supremacy." She has a problem with her computer. She calls IT. The IT employee comes by and sees the photo, interprets the words white supremacy as code for Trump, and therefore says it's a direct challenge to his own conservative views. The IT professional then wants to put up his own sign that says, "Deport all illegals." So this issue, quite easy to see it happening. Victor, this one hits your desk Friday at 4:45. How do you handle it?
Wow, at 4:45. Well, hopefully I've maybe signed off by then, but not in this world, right? And this is when they do hit, right? Because fundamentally, as I said in the beginning, we're problem solvers, and so you have to again step back, take a deep breath, because when you look at the words stop white supremacy on its face, you might think, well, everyone, would come on board with that, or possibly should come on board with that, and why is that's somewhat, innocuous. But, words have meaning, and people can interpret different things different ways, as it was for this individual who saw that as, oh, no, this is actually code for something else, and it's code for, the political party that I'm, affiliated with, and I am offended by that. So I think this is when legal and HR, again, work together to figure out how to diffuse the situation, how to de-escalate, and how to maybe use this as a teachable moment to actually open up some conversation. From a strict legal perspective, you could just make the judgment that, well, we're just going to have both of these signs taken down because we don't want to have any sort of disruption in the workplace. If we're going to remain neutral, we can't support the stop, the white supremacy sign, nor can we certainly support the deport all illegals sign that could offend coworkers, could offend visitors to the office. And so you could just sit there and say, we're going to take them both down. But I don't think that's just the end of the story. And so I know Dr. Murray's going to have some comments as well, too. So I don't want to steal her thunder. And maybe we can have some dialogue about how to address this and how to get to the underlying tension that may exist within this situation.
Dr. Murray?
Yes. So 2 initial thoughts. The first is that I would not want to work in Victor's office on a Friday afternoon or a Monday morning. But my initial response to this situation is to approach this conflict as a disagreement and an argument that's not always bad, and it's necessary for personal as well as organizational growth. When examining this situation before us, I would employ the 6 E's for effective conflict resolution. Embrace that the conflict exists, educate the individuals engaged in the conflict about where the particular breakdown occurred, engage the participants to make sure that they know and understand that their voices are being heard throughout this situation, empathize with both parties because their worldview, their personal values are actually at play when we look at the particular symbols and meanings of the conflict. Empower people to feel comfortable to express themselves in a safe and protected manner, and then encourage individuals to engage in respectful discussions, because this is a breakdown in not understanding communication. And so I'll say those again. They're the 6 E's for effective conflict resolution: embrace, educate, engage, empathize, empower, and encourage.
Oh, Dr. Murray, I love that. I mean, it's just because that's a beautiful framework. And I really do think that in-house counsel as well are having to kind of go into this area as well, and not just be, legal pundits, if you will, and say, well, this is what the law states and this is the way we're going to do it, and we're going to resolve it this way, and we're going to walk away and everything is fine, because it's not fine. In the sense that those lingering views are still there. These are deeply held views for people. And so we still have to address that underlying tension and underlying beliefs in the workplace and have a conversation about it, do it in a respectful and an empathetic way. And I think it's challenging the legal counsel that are on this phone, that are practicing in corporations, to be willing to go beyond just giving the strict legal advice, but also going in and trying to be a true problem solver and keeping the ultimate goal in mind of the workplace, which is to create harmony in the workplace to the best extent practicable, and to try to diffuse and minimize disruptions.
Right. When we think about conflict, I want us to all remember that, number one, everyone's not always going to get along, and it's okay. But we have to look at the human side of the conflict and to think about how should we extend grace to those individuals that are engaged and involved in the conflict.
Well put, both of you. Really good stuff, Dr. Murray and Victor. So Danny, while employers are drafting their policies about political speech and expression, even those that, as it relates to social media and off-duty conduct, should they be concerned about the NLRA about restrictions on free speech?
The NLRA always is like this relative that you always have to remember to invite to the party, whether you want them there or not, because it applies Section 7 to every workplace, whether you're unionized or not. And essentially, it tells us that we cannot interfere with the employee's right to discuss the terms and conditions of their employment. That's the protected concerted activity that falls under Section 7. So a policy, most policies need to have some reference to that policy not intending to prohibit that discussion between employees about the terms and conditions of their employment. And the NLRB, I think, does, I know at least one participant posted a question about this, but they do a really good job, I think, about putting some model policies up of what they believe does not violate Section 7. So that's always a useful place to look as well when drafting some policies. But I know that our last hypothetical is probably one that a lot of participants already asked the question for our last hypothetical in this presentation. So that's all I'm going to say about NLRA, so we can kind of get through to our best hypothetical yet to come.
Wonderful. I want to ask you a quick question, though, Danny, and it's not specific about the NLRA, but it is about these policies, right? So if a company wants to implement a policy that seems neutral on its face, say, for example, they want to restrict talking about the border wall at work or talking about defunding the police at work. Do you see any problems with that?
Well, as you mentioned in the earlier takeaways, the important piece is to be neutral, and that means truly neutral. So you're not looking at it from a single subject matter of, well, we're just talking about police and whether you can talk about defunding the police or not, but we're talking about sort of broader issues, both sides of the coin, so that the policy is going to apply to everyone as it relates to that particular subject matter, which may be broader than just one particular, it's going to be broader than one particular side of that.
Right. I agree with that. And I'd also like to point out, just as an observation, that a lot of times the intention is to be neutral, but it has a disparate impact, right? So if we start talking about limiting speech as it relates to the border wall only, well, guess what? It might be that Hispanics may be disproportionately restricted in their speech. Or if we talk about defunding the police, it might turn out that Blacks may be disproportionately restricted in their speech. So as Danny said, I think it's really important for us to have a broad enough policy that applies to everyone. And so quickly here, before we move forward to some of our other questions and hypotheticals, restrictions on speech have implications beyond just legal implications. So we've spent a lot of time talking about sort of the legal risks that are involved, but there are also non-legal risks too. And that includes, bad publicity. I'm sure we can all think of a company or two maybe that have received bad press for restricting their employees' right to express speech or expression. So companies should try to be mindful of that as they're crafting, deciding whether they want to restrict free speech or speech at work or not. And they should also be mindful that restrictions on the speech itself could cause employee morale issues or even employee protests. And so, Dr. Murray, I'd like to ask you if you have any tips to offer sort of about how to combat some of those problems in terms of employee morale issues or protests from employees who want to express their speech and are not given the opportunity to.
So first, Organizations must acknowledge that difficult moments are occurring, whether they're internal inside of the organization or that they're happening around. You cannot think about your employees as people that turn off their emotions, their feelings, their thoughts once they walk through the door, or in our COVID-19 case, log into a computer. So acknowledge that difficult moments are occurring. The second thing is to create these safe spaces for critical conversations. I mentioned earlier the importance of having these employee resource groups. Host coffee and tea breaks, virtually or face-to-face, where people can have judgment-free discussions, and they're allowed to safely engage in comments and conversations where they are in a position to learn. Organizations cannot act as if people aren't constantly in a state of learning. And then for me, the most important comment or way to think about this is to reward allyship. So there are going to be individuals within your organization that will not feel comfortable asking questions or speaking up. And so as a company, think about how you can reward those individuals that act as allies in situations that are deemed uncomfortable.
Thanks for that, Dr. Murray. And Danny, let's talk a little bit about the flip side of that. So we talked about sort of the implications for restricting speech at work. What about some of the implications for allowing it?
Right. We've talked a little bit about how once you allow that speech, you have to make sure that if it carries over into a place that's going to be harassing, that's going to be threatening to people, that the employer then has an obligation to respond to that speech and act in that situation where it is becoming harassing or threatening to an individual within the workplace. And the SHRM conducted a study last year, and I think the two call-outs at the bottom of this slide are really interesting, that almost half of working Americans have personally had a political disagreement at work. I would be curious to see if that number's gone up or has changed from last year to this year, given that it is an election year. And then the second statistic listed there, that 10% of working Americans have personally experienced some differential treatment or based on their political affiliation and a bias that exists at work. So there's disagreement happening. There's, people are feeling some effects of that bias when they're having these disagreements at work, which takes us into, Dr. Murray, we know that's happening given those statistics. So how can we really, what are some tips for managing that?
So one, we've talked about the policy throughout this presentation, but organizations must communicate company policies regarding political expressions in the workplace. How are organizations communicating their values, especially in this particular remote workplace environment? How are we still engaging our employees when it comes to company culture, company morale, company values? Are these values being affirmed by leadership? If you are a leader that's on this call, how often are you checking in with your team members? Not about the product or accomplishing work, but like genuinely checking in with people to see how are they doing from a place of care. We also need to think about, and I go back to this all of the time, create these spaces where people can discuss tumultuous climate outside of the scope of work. Recall that political beliefs and views are all extensions of human emotion and who we are, and we want to encourage healthy dialogue. And then last but not least, redirect conversations from keeping them from getting out of hand. When we think about the fact that this is an election year, tension is high, we have multiple pandemics occurring at this very moment, we must engage in being supportive of the differences, but also demanding respect when it comes to the differences.
I agree with that for sure, Dr. Murray. One of the things that we are seeing a lot of companies do is take a public stance on a political issue in today's climate. So we've got another poll question for you, the last one of the presentation here. And it asks, has your company taken a public stance on a political issue? Companies do enjoy First Amendment rights to speech and to control its own message regarding matters as it relates to public concerns. So it's perfectly fine for companies to take a stance, though it's not a requirement. So we like to hear from you in terms of what your companies are doing or whether they have chosen just to stay out of it altogether. As the results come in, Victor, I'd like to ask you, since you've worked with a lot of different companies, a lot of different places, what your experience has been in terms of companies who take public stance on political issues.
Sure. So thanks, Vanessa, for the question. Yeah, I will say quickly as we're approaching the top of the hour, for KBR, we did publish a statement internally to our employees, appropriately entitled, Coming Together During Times of Difficulty. It was something that was published by our CEO and the chair of our corporate board of directors, who's a retired Air Force four-star general, who also happens to be African American. But within that statement, we basically reaffirmed our corporate values of mutual dignity and respect in the workplace. We took the time to reaffirm our commitment as a global company to inclusion and openness, and that racism has no place in society and our company as well, too. So we did take that opportunity. Overall, it had a positive impact on employees and gave a lot of good dialogue amongst our employee resource groups and those courageous conversations that you spoke about, Vanessa, and to Dr. Murray.
Great. If we could close the poll results here and see what we have in terms of our participants. And I will say as the poll is closing, we may be 3 to 4 minutes over on time, so those who need to jump off, please feel free to do so. We'll wrap up our last few slides momentarily. So the results are in. It looks like it's about a little bit more towards no, but almost half and half in terms of those who responded about those companies who have taken a political stance. So I would like to talk about a little bit of additional considerations that companies should consider, particularly companies who have decided to take a political stance publicly. So one of the things to sort of keep in mind for those companies who've taken a public political stance is that, as it relates to your employees, you need to keep in mind that you are allowed to have freedom to control your own messages regarding your political speech, but you're not allowed to force your own personal beliefs on your employees, right? So it's not a good idea for companies to require, for example, all employees to wear a rainbow T-shirt in support of LGBTQ rights. It could go against some people's religion, as they say. So we have to be mindful of that, so that we're not forcing different beliefs on people. Though the intent here is good, right? To provide, to support diversity and inclusion efforts and support of LGBTQ rights. We also have to be mindful of those who say that is a violation of or against their religion. So we don't want to force that on others. And we also want to make sure that to keep in mind that employees, to remind the employees that they should comply with anti-discrimination and anti-harassment policies. Dr. Murray, do you have any advice for employers as it relates to sort of the organizational culture or workplace conflicts that may arise?
Quickly, I'll go back to my earlier example of Wakanda. We have multiple T'Challas and Killmongers within our various organizations, and we need to remember that there is space for both of those individuals, and that we should think about how our organizations are a microcosm of Wakanda and all of the 6 tribes.
Thanks, Dr. Murray. And so we've reached our final hypothetical, and then we'll conclude for the day. It sounds like this hypothetical may be much anticipated. So Danny, take it over.
All right. So a company issues a public statement expressing support for the Black Lives Matter movement, right? About half of those companies, we said, that have issued statements around political type issues. The following day, employee A asks to wear a face mask that says Black Lives Matter, and employee B asks to wear a face mask that says Blue Lives Matter. So these two terms, Black Lives Matter, Blue Lives Matter, have in some ways become politically associated movements. And so now you have employees asking to wear those masks. Victor, this one's coming at you middle of the week. What do you do?
Well, first of all, I'm going to renegotiate my speaker fee with Seyfarth for giving me all these difficult questions to answer. Because there's really a very difficult situation, particularly in the hypothetical where you have the company has come out and expressly supported Black Lives Movement matter. So you have not just a reaffirmation of the company values, but you've actually had a more proactive, I guess, support and promotion of Black Lives Matter movement. And so it's hard to tell employee A when they come in the next day that, hey, you can't wear that when you've just published a statement that said, we support you. So, on its face, you're like, okay, well, yes, we did just say that. But then when someone wants to wear the Blue Lives Matter, which for me personally, I don't see them as mutually exclusive, but they've been politicized that way, and we've been divided. You have to choose between one or the other. So if you're trying to remain neutral, the legal response may be that we're going to disallow the mask of wearing of any kind in order to keep and minimize the disruption. But the trickier part of that is now the company that defeats the company's purpose of wanting to support the Black Lives Matter movement. So I know, Danny, you and I had a brief conversation about this before this presentation, and one of the things companies can think about is if you do take the step of disallowing both masks, Black Lives Matter and the Blue Lives Matter mask, think about other ways that you can support the Black Lives Matter movement by allowing employees to have time off work to participate in political expression activities or voter registration drives, or some other ways that you can do it that doesn't create a situation that's divisive in the workplace if it's reaching to that point, because you don't want to just give up and just throw your hands up and just say, well, in order to be politically correct and keep the peace, we're just going to disallow it without in totally backing off your support. So I would have a nuanced approach here. It could be that given the facts and circumstances, we may decide to just remain neutral 100% and disallow both masks, but we might think about other creative ways that we can still adhere to our company ethos and support and do corporate social responsibility.
Thank you to the folks who are still hanging on to the presentation. Dr. Murray, do you have anything that you'd want to add in managing that hypothetical in the workplace?
And so two things come to mind. One, there is a Brian Stevenson quote where he says that there is no path forward without some discomfort. And so I would like, in terms of organizations thinking about the Black Lives Matter movement and statements such as All Lives Matter, they were created to directly oppose the Black Lives Matter mission and movement. And so in ways where organizations may be thinking that we can prohibit those statements to avoid undercutting the Black Lives Matter movement, consider what does it mean for a Black life to indeed matter over a statement of a uniform in particular mattering.
Mm-hmm. Yeah, that just being comfortable with discomfort can be one of the hardest things in this space, and it's so not a legal path. There's a lot of comfort sometimes in the legal path that reminding ourselves that sometimes it requires discomfort is important. And especially as we, our last slide here talking about some of the conclusions and takeaways from today, that companies definitely are free to engage in expression. That's why there are so many that have come out with statements in support of different movements. You have to be aware of those EEO concerns. And as we all know, they come from all directions, right? EEO concerns are not just going to come from one particular cohort of employees or one particular group. We talked about some state law issues and just making sure that you're checking into the particular state when the issue is arising with that particular employee. Being consistent in enforcement, whether it's enforcing your policy, enforcing your organizational culture, enforcing the tone at the top, being consistent in doing that. NLRA, you got to invite the NLRA to the table and make sure that you're considering it in the course of all the decisions that you're making. And some of those E's that Dr. Murray talked about, that's a great thing to walk away with, of encouraging dialogue that we started here, empowering the differences that we have among us, and embracing the diversity, because that's how we all contribute to make this better. And with that, I'm sure I speak for all four of us, sincerely thank those who joined us today for participating in this conversation. Obviously, there's a lot more that we could have talked about. And my co-host,
Thank you.
Thank y'all.
Thank you so much.